Good afternoon, good evening, depending on your time zone. Thank you very much for joining us at the 2025 Climate Law and Governance Day, and welcome to this special legal workshop, Defending Climate Defenders, Climate Litigation, Compensation, and the Legal Mobilization of Local and Indigenous Communities, which was hosted by LACLIMA and will address focus questions such as how can climate litigation be used as a tool to defend Indigenous peoples and local communities facing climate related harm? What forms of compensation and reparation best address the historical and ongoing injustices experienced by climate defenders? And in what ways can judicial and non judicial mechanisms promote more equitable and community driven responses to the climate crisis? This is a participatory legal workshop, and I will hand the floor over now to the chair, Dr. Gabriel Mantelli, Senior Policy Advisor at La Clima. Gabriel, the floor is yours.
Thank you. Hello, everyone. I hope you're having a great time in this course. I'm speaking now from Brazil. We are having our COP30 in the heart of the Amazon. The weather here is really hot right now, but we are happy to have people from different parts of the world here in Brazil. And before I introduce the main ideas of this session, I just want to remind you that this session is a workshop. So I need you to be here, be present with me. If you are able to open your cameras, I would thank you a lot, because the idea is to promote a conversation between us, students and professors and legal practitioners, because I know that the other sessions were more like lectures, but this session is more like a workshop, as the title suggested. So the idea is to have you here, because part of my presentation is not only talking about climate compensation cases, but also I want to hear the ideas coming from you, from your territories, from your jurisdictions, from your legal backgrounds. So if we could just adjust this in the beginning of this session, I really, really would appreciate a lot. In the meantime, I'm going to introduce myself. Thank you, Tejas, for the quick introduction. I'm a Brazilian lawyer. I live in the south part of Brazil, which is the city is São Paulo. And I've been working with climate law in the past 10 years, and with climate litigation in specific in the past 6 years in Brazil, being part of this movement of climate litigation in the Global South in general, but particularly here in Brazil. And we brought to the Supreme Court in Brazil, several cases, but also in the lower courts, helping and providing legal assistance to different types of groups, not only indigenous peoples, but also here in Brazil, representing this idea of the natural rights, the nature rights of bringing the cases to the courts. And LACLIMA is an organization that is providing support to this court as a whole. And LACLIMA is working now here in Brazil with several subjects and negotiation pathways in COP30, but also we are promoting a lot of events now here in Belém. We had yesterday a great event about climate justice, what was incredible. We heard from different practitioners from around the world, so it was amazing. And we also had a local dance here that is called carimbó, which is really amazing. So we are trying to combine all the efforts that we're doing here with climate law with what is happening here in Belém. So again, the idea is to have you here with me to talk about climate compensation cases. I'm gonna share my slides with you, and I hope we can have a great session. I am really excited about this. Just a second. Oh, yes. Okay. Tejas, is it working again? Yeah, sure. Thank
Yes,
you.
Gabriel, works well.
Amazing. So again, it would be amazing if I could see you guys and if you could participate. I know that students, independently where they come from, they don't want, they don't like to open their cameras. I think we're all like traumatized by the COVID experience that we have. But for us teachers, it's important, and professors, it's important to have you here with us, because as you choose to be part of a workshop, we have to work together, or because that is not me just to talk a lecture. Otherwise, you could choose another type of session. So again, my name is Gabriel. I'm a lawyer in Brazil. I'm also a PhD and a lecturer here in environmental and climate law, working in the intersection between legal practice, academia, and social and civil society organizations. And the idea of these workshops to talk about how can we defend the climate defenders. I know that especially in the countries from the global south, as Brazil, we have a lot of concerns about the protection of the people that are protecting the nature. We're going to talk about this, but we have like high rates of people getting killed just because they are trying to protect the forests and the rivers, especially when we are talking about again, thinking about Brazil, when we're thinking about indigenous people that are in the front lines, and also Afro-descendant people here in Brazil, we have a lot of problem in terms of racism and killing of young Black people here in Brazil. So the idea is to talk how can you use the law and the legal tools to defend these groups of people. And I'm gonna try to talk a little bit about how climate litigation, and I would assume that part of you guys have some experience with climate litigation, or maybe work in something related to climate law or litigation in general. But of course, if something is missing, you can just put your hands up using, of course, the Zoom tools. And I would love to dialogue with you and provide more information on the questions. So the idea is to talk about, again, defending climate defenders, climate litigation, compensation, and the legal mobilization of local and indigenous communities. I choose to use the idea of legal mobilization because when we are thinking about how can we use the law, in some countries or in some types of jurisdictions, there are only a few options in terms of how can you use the law, how can you use, for example, litigation tools. But, Tejas, sorry, if my connection starts to get unstable, could you just highlight to me, please? Is it working well? Okay, because I think it's not, again, I'm
Yeah,
in the middle.
absolutely.
Yeah, I'm in the middle of the Amazon right now.
I can only imagine. No, please do continue. If anything goes wrong, I'll come in and help.
Because I can try to move to my cell phone. The
No,
internet in my phone
it's
is
all
okay.
clear. We can hear you clearly. It's working
Okay,
fine.
thank you so much. Uh, I was mentioning that the idea of using the the tool of legal mobilization. Thank you, guys. The legal mobilization is because when we're thinking about climate litigation or other types of litigation, we have this idea of just using the judicialization course or the judicialization pathway of bringing a case to the courts and waiting the courts to have to provide a response to our claims. But when we are thinking about legal mobilization, we can access a broader scenario, which includes not only talking about litigation per se or the judicialization, but other types of mobilizations or other types of mobilization that are connected with law. For example, I used to work in the past 7 years. I used to work to a human rights organization here in Brazil. And not only we were litigation, we are not litigating in terms of the climate litigation, but also we are providing campaigns, we are putting together technical and scientific efforts in order to our case becoming more appeal to the public opinion, and we are articulating with social movements, and we are articulating with groups that were or are impacted by the climate crisis and so on. Hello, HP from Benin. Great to have you here. I'm here in Brazil, in the middle of the Amazon. And so the idea to talk about legal mobilization is to try to bring to you a broader perspective of how can we engage in this climate litigation movement, not only thinking about just law and the books and the rulings and the courts, but also thinking about the people that are impacted by the climate crisis. How can we build, for example, coalitions between the academia, the human rights society, the human rights groups, the civil society, and other types of, for example, here in Brazil, we have a lot of public institutions that can help when we are thinking about the defense of human rights. So we can, for example, make a coalition between a Brazilian organization and the the public defender's office, for example. Hello also to Sierra Leone. Hello from Brazil. But let's try to start our conversation. First of all, why litigation matters now? That is what I was trying to say. That climate litigation is not only to talk about the process and the procedures itself. I think nowadays we are talking more of a broader field and a set of legal and maybe socio-legal tools that we can put in conversation. So here in this session, in this workshop, our hello to India também, lots of places here, a massive presence of the Global South, which I think it's fundamental. So the workshop here is the objectives are to map current global trends in climate litigation and threats to climate defenders. This first objective is, I was thinking not only to talk about climate litigation, because we have a lot of courses about climate litigation in general, but to try to bring the perspective of the climate defenders. What are their main threats they are having right now, again, especially in the countries in this global south. Discuss key cases involving indigenous and local communities. I'm gonna try to bring some Brazilian examples during my presentation. Explore some types of legal remedies, which include legal compensation, reparation. We are here in Brazil right now talking we are talking a lot about climate litigation and structural cases, and that means we are talking about big cases that we can bring, for example, to the Supreme Court. I'm just having some return of my mic, I think. Okay, that has just, yeah, thank you. And again, the idea is to let's try to put together this workshop format. I am counting on you guys to have a, not me just talking, but we have a conversation here with some sort input, some case spotlights. I'm not sure if we're gonna be able to do small group discussions, but I'm gonna maybe turn this into opening questions and some questions that we can discuss together. And in the end, I'm gonna open to a plenary sharing of what we discussed today and what we can learn with this dialogue. I'm also receiving some hellos from Norway. Hello, Norway, and Tunisia. Hello, Tunisia. As we say in Brazil, olá. Okay, so let's start to talk about climate litigation. I know that I believe that some of you know that climate litigation has been a growing field, a growing movement in the past years, especially when we are talking about the moment that we have after the Paris Agreement. And we had some very important cases, like when we are thinking about the Uganda case in the Netherlands, for example, or when we are thinking about the Pakistan case, which was really great and important too. But not only the cases against governments, but also we have some climate cases against companies. We have some climate cases that are famous, that are against Shell, for example. Here in Brazil, we have some cases that are against deforestation, private people that owns lands that were deforested. So we have this type of case here in Brazil right now, and the data that we have nowadays, which is mainly produced and centralized by the Sabin Center in the Columbia University. But here in Brazil, we have a Brazilian university, which is the Pontific. I don't know how to say that in English, but it's our PUC. It's a university that is related to the Catholic Church. But we have this institution that is putting together a lot of data of the Brazilian cases. And according to our data that we have nowadays, Brazil is now the first country in the Global South in terms of cases. We have more than 300 cases, and most of them were filed in the past 3 or 4 years because in Brazil we are very concerned about the climate crisis, but also in terms of the political context in Brazil, which enable the civil society and some public institutions to bring those cases to the Brazilian courses. But at the same time that we have like these new jurisdictions, sure, Maria, I can send you the name of the group that it's a research group from the PUC Rio de Janeiro, PUC Rio, and the group I'm typing for you. It's called, you can find it online. It's JUMA, because in Portuguese is like justice and environmental, is Justiça e Meio Ambiente, is JUMA, and the university is PUC Rio. We have a Brazilian database, which, and these databases send the cases to the saving center. So PUC-Rio and the saving center, they have a partnership. So every cases that we put together here in Brazil, we send the information to saving center. But we had an explosion of cases in the past year because there is a legal entity here in Brazil that is the public attorney's office here in Brazil. They brought like 150 cases just in one day, because it was part of a public project to protect the Amazon, and that's why Brazil is now the second country in terms of number of cases, just following the US. But in terms of the Global South, we are leading right now in number of cases, of course. But not only I talk about climate litigation, which is important um, to understand where are we right now, what we are doing. But as I mentioned before, the idea of this workshop is to try to put together what climate litigation is trying to do, and what are the strategies that we can connect to climate litigation in terms of protecting the people that are protecting the earth. So the idea, how can we bring the tools of climate litigation into the protection of environmental and human rights defenders? And that's not an easy task, because for a long time, the fields of the climate law, the environmental law, the climate litigation, the environmental litigation, and the field of the protection of human rights, the human rights legal regime, they were like disconnected. But nowadays we can see more and more that these fields, in terms of course, I'm talking about the legal fields, not the political field or the social movements that put this together long times ago. But I'm talking about, for example, just in the past 4 years that we have now a UN special rapporteur of climate change in the UN Human Rights Council. So that's an indicate that for a long time, the human rights regime and as I say here in Brazil, the human rights people and the people that works with human rights, they didn't talk too much, or they didn't have like the legal instrument to talk about or to talk with the environmentalist movement, the climate defenders. So that's why there is also in the legal literature this movement of greening of human rights. I don't know if you ever heard this idea that more and more the human rights are being greened, and they are becoming more green and more green. But not only because we are greening the human rights regime, but I believe with now the advisory opinions that we had this year, and I believe in the other sessions, lots of people talked about the advisory opinions. We are not only seeing a greening of the human rights regime, but also we are seeing climatization of the human rights regime. They are becoming more climate oriented, more climate based than before. And this, and I'm talking about this because for a long time, the protection of human rights defenders and the protection of the people that are defending the nature, we were doing this in separate ways. And nowadays, more and more, we are trying to put this together. And that's why we're gonna try to talk about how climate litigation can help to defend the people that defend our planet. Hello, bonjour from Canada. Hello, David Boyd. Amazing to have you here. We met before in some COPs, and I'm a huge fan. Now David Boyd used to be our UN Special Rapporteur for the environment, so it's a big deal having him here with us. So thank you for being here and being part of this conversation. And now the idea is to put more. And that said, David Boyd was one of the leading persons that helped us to green the human rights regime. He was part of bringing finally the human right for the environment, and that's what I'm saying for the past 70, 80 years, I don't know, of the UN and the Human Rights Charter. Just like 3-4 years ago, we have the human right for the environment. In my country, Brazil, we have the fundamental right for the environment since the 80s with our constitution. But we know that in different countries, a lot of the countries around the world, they don't have the human rights or the fundamental rights for the protection of the nature, for the environment, and consequently for the climate defense. So David Boyd is one of the guys who brought the human right of the environment for us. So thank you again, David. It was amazing. But moving on, why focus on climate defenders, local and indigenous communities? I was mentioning in the beginning of my conversation with you guys that when we are talking about climate defenders, especially in the global south, I know for the majority of those that are listening to me, that's not a new idea, a new concept, but of course we know the data show that the climate defenders, the people that are most impacted, the people that unfortunately that are killed in this process, in all these struggles that we are living right now, are often indigenous people, Afro-descendant communities, small fishers, local communities, grassroots movements in Brazil. Besides the concept of indigenous peoples, we have also the concept of traditional people, which includes quilombolas, which are here in Brazil, people that are descendant from people that are Afro-descendant, that have traditional ways of living. And not only they face all those struggles that are related to inequality, racism, exclusion, they also face legal and political risks. And we are talking about strategic lawsuits that are targeting protests, the free speech, the free organization of those groups. We are talking about the criminalization of land occupations, roadblocks, and direct actions. Here in Brazil, we have a lot of problems regarding the demarcation of indigenous and traditional land, because here in Brazil we have a law that says that indigenous and traditional communities, they have the right to have their lands, their ancestral lands. But unfortunately, here in Brazil is like a big, that Brazil is a big country, and part of the political control of our country is concentrated in the hands of the agribusiness, and the agribusiness is always putting an agenda. There is not an agenda there is not in dialogue with indigenous people here in Brazil. That's why we have lots of indigenous land litigation in Brazil going right now. I don't know if you ever heard about the discussions about, we have here in Brazil a legal thesis that is called in Portuguese Marco Temporal. In English, something like the time frame thesis, which says that people, indigenous people in Brazil, should be in their lands in the date of our constitution, which is crazy. But not only they are facing these types of these multiple layers of risk, they're also facing direct violence, disappearances, killings. I don't know if I put in these presentations, but Brazil, Colombia, sometimes Ecuador. These countries are the countries with the rates of killing human rights and environmental defenders. The rates here are really high. Brazil is unfortunately, is always winning these rankings of killings of human rights defenders. And in response to that, we have some tentatives of human rights treaties, like the Escazú Agreement. I think that people from the Latin America and the Caribbean region, I think they may have heard about the Escazú Agreement. Is an agreement that tries to put in forth more legislation to provide a safe and safe environment for the human rights defenders. Here in Brazil, we are trying for many years to put this agreement in force. I know that for the COP30, there was some movement in our Congress, and they approved in the Senate, and now they're trying to approve in the National Congress, because here in Brazil we have this bicameral way of approving human rights treaties, and we are trying to put this in force. I know that some people are trying to put this. I hope they do. And after that said, I'm gonna try to bring the first question, and I hope to have some colleagues that help me to have this conversation. And the first question is, how can climate litigation protect defender instead of exposing them to more risk? That is a great question, because as you may be aware, when a social movement, when you have, for example, an indigenous leader that lives in the global south, and he's been acting and mobilizing people in all his trajectory, and then he tries to bring a case using the courts. People that don't like this indigenous leader may start to impose some violence against them. And one of the main concerns of when we are putting together a climate litigation is, how can we trying to protect that family or that leader or that group? How can we, in bringing a case to the courts, how can we not do the opposite? Which I'm trying to say that, how can we guarantee that the people that we're trying to defend are not gonna, for example, be killed during the litigation course of the strategy, being I don't know, suffering other types of violence. So the idea is to hear your thoughts about this. How can so what can we do? So is it possible to bring climate litigation to protect the climate defenders, or are we going to expose them more to these layers of risk that we are starting to speak here. Of course, we can do some parallels with other types of human rights litigation for those who are studying or used to litigate with human rights issues. But let's try to bring a more climate litigation perspective here in terms of which are the strategies to not expose them more that that we could. And I'm gonna like to have some people talking with me. If you are shy, you can use the chat because I can read, you know. So again, the guiding question, Tejas is helping me. Tejas is amazing. How can climate litigation protect defenders instead of exposing them to more risk? Question, how can climate and environmental defenders be adequately protected, specifically where the threat emanates from the state and big business? Yeah. So the idea is to not put more questions, but to try together to put the answers, right? How can you see that from your country perspective, from your history engaging with the law, yeah, or your general ideas? Tejas is saying that we could try some breakout rooms, so we would have some smaller groups, and maybe you would feel more comfortable not sharing the ideas to the open class as a whole. What do you think? Oh, we have Yusuki. Please go on.
Okay, thank you. I'm not necessarily working on this, the climate litigation, but I've been supporting lots of defenders litigation on the other sectors. But so I think the first question is that whether the litigation is the best kind of option to pursue the goal. So because some of the country, I'm here, I want to hear more from you, but since I'm not super familiar with the Brazilian context, but many countries the court exists, but the protection, I mean the safeguard is very, I mean safeguard protect, I mean the safeguard for the whistleblowers or defenders are generally inadequate or lacking, so it's kind of difficult to protect anyway. And then also the defender themselves need to be better informed about all kind of risk, because sometimes the defenders start kind of harming their communities by their own deeds and words. And so it's actually that they started with the good cause, but sometimes it's just become a very counterproductive to the bigger communities because how they behave or how they, I don't know, spoke out publicly. So I think there's no panacea on this, but I think that's something that I always keep in mind, and then having the conversation with those defenders whenever I had a chance to work with. Over.
Wow, really good. Yusuke, where are you from?
I'm originally from Japan, but I'm part of the UN community supporting defenders.
Nice, nice. Let's hear from Professor Ayodele.
Yeah, hi, good evening. I'm glad to be here. Can you hear me? Okay, cool.
Yes, nice to have you here.
Yeah. Okay, so I am Ayodele from Nigeria, and I wanted to say, because I know you've talked about Brazil, but here in Nigeria, although the focus then was not climate, but it was still environmental based, we've had a situation in which the government executed a group of people who were fighting for environmental rights and all. The Ogoni case, it's known, and it has to do because, of course, this was in the Niger Delta region of Nigeria, and where we have a lot of oil, and the communities there are generally just suffering as a result of the exploration and production activities going on there. Now, for Nigeria, oil being the mainstay of the Nigerian economy, and it has been for several decades, it seemed almost imperative that they need this income, and they were not going to brook any dissent or any interruptions to the productions of the multinationals. And so there have been accusations of complicity on the part of the big oil companies and human rights abuses within that region. And I think, the question I pose is how do you protect the defenders when it's the state that is actually the one that is the aggressor and taking away their rights and their lives? In Nigeria, I think the issue, of course, is always what plays out political will. How much of political will do we have? But also a lack of strong institutions, because we have various regulators on various levels, various industries, but especially within the oil and gas industry over here. However, you find out that they're not doing their jobs to the best of their abilities. And once in a while, when you see, we had a case where the court had said they should stop flaring gas, but the petroleum minister's spokesperson has said that is not going to happen. So it's always the financial concern taking over human rights considerations. And so even the regulators, because the regulators are there and they're controlled by the executive. And so no regulator is going to go and shut down oil operations, because whoever is in charge is likely to be removed and dance to the tune of the executive or the government of the day. So even once in a while, when you have the courts actually grow some spine and issue judgments and orders, they tend to be ignored. So we have a problem with strong institutions. And like I said, a political will. That's what I see from our end. And so we have to build that up. But unfortunately, it's not something that is going to be done in a day or in a short while. So now is to think of how do we balance these human rights considerations with the overarching, what the country considers is economic benefit. And that's all I have to say for now.
I just wanted to, oh, sorry, go ahead.
No, just to comment that this is amazing because we are putting more layers of complexity, because again, we're talking from different political contexts, different histories of the law can function or not function in our countries. And again, it's amazing that we could maybe try to build a puzzle in terms of understanding these different types of the ways that law can work or not in our countries, depending on the political, the social, and historical context of our jurisdictions. But go on, Rachel.
Thank you. I just wanted to jump in on the Nigeria example, and I wanted to bring in my comparative research on New Zealand. So for the past couple of years, I've been working with mining host communities in Nigeria. And one of the challenges with resource-rich communities is that people don't have agency and they don't have a stake in the decision making. And so one of the things that we try to do in our work is bring more agency to the mining host communities. So I think when you think about Nigeria, the resources are controlled mostly by the central government. And so looking at this question and thinking about the intersection of human rights and the environment, I think it starts with having people defend and safeguard their own natural resources. And when you have the national government controlling everything and local communities don't have control over their own resources, that to me is one of the biggest issues. And so in my home country of New Zealand, I've been looking at rights of nature and thinking about how you can look at Indigenous perspectives of the environment that focus on coexistence with the environment and reciprocity. And you can make sure that local communities are actually the ones protecting their own resources. So I think that framework is something that could be applied, and it already is being applied to so many different global contexts. But I think it goes back to what we mentioned earlier with the intersection of the environment and human rights. When you have the environment being protected by the people who live there, and when you have governance frameworks that focus on that, that's how you kind of get out of this resource extraction framework.
Nice, Rachel. More thoughts, guys?
Gabriel, there seems to be some interesting thoughts in the chat, but I can see
Okay, let me see the chat. But
Yeah.
go on, please. Shukumuma, you go on, please.
Okay.
Thank you.
Thank you.
Thank
you very much. I listened to your presentation, then the professor from my country, Yodele. So I'm a Nigerian. So based on what she said and trying to find a balance in access to resources and control, how the communities come in. Nigeria has a policy on revenue sharing, whereby there's provision for 13% of revenue that comes from the oil resources is demarcated to be returned to the states from where the revenue is generated. Then as a lawyer, I've been involved in drafting some oil-related, petroleum and gas oil-related contracts. I know when companies come to do exploration and production, generally the ministry involved makes a demand for proper environmental impact assessment to be sure that whatever will be done does not have a negative impact on the environment. Or what we find out is that because the communities engage the contractors and the government through their leaders, what we call stakeholders engagement. Often we notice there's corruption and complicity within the communities that should be demanding for the interest of their communities. Often what we see is that the elders that form the leadership of those communities get involved in compromising their interest and being settled with a little amount of money, then they will forgo the agitation to defend the interest of their communities. So these areas should be looked into. It's not always that the government does not want to help the communities, but their leaders are compromising in not helping them to push for their interest to be defended. So the resources, particularly the area on how the revenue of the country is specially designated, 13% derivation for development of that region, we notice that their leaders, the governors, legislators from those areas, you see them, their lifestyle and the expenses they make does not show in line with the region that requires development. So they waste the resources instead of using it to develop their area. So this area, if there are other countries that are going through, they should look into how to manage their stakeholders and leaders in paying attention to make sure that whatever is mapped out to help those regions are actually used to do what it should be done. Thank you very much.
Thank you. That's also really interesting. So I'm gonna read some of the chat the chat content. So Julia said shifting the burden from defenders to institution to reduce personal confrontation, hence reducing the risks. But Julia, but when we don't have like institutions in some countries, what we do? And when we don't have institutions in some countries? No, I'm just more food for thought here to us to think about it. But of course, it's a great strategy when you have a country where the rule of law is working and the institutions are functioning and so on. Rita said, seek interim injunctions. It's a good procedural strategy. Precautionary measures involve the public awareness, international publicity. I think this is also great. I was also thinking about building international coalitions and transnational cases. So we don't put all the burden of the case in someone's head. For example, we're not put the people that are affected in the line of the risk. David was saying the recent court judgment in the U.S. against Greenpeace. I think everyone heard about this case. The recent court judgment in the U.S. against Greenpeace, awarding 60 million in damages to a company called Energy Transfer for Greenpeace involvement in a pipeline protest is very disturbing. It highlights the importance of having legislation in place to prevent SLAPS suits. SLAPS are the strategic lawsuits against public participation. We are having some SLAPS suits here in Brazil. They're not common here in Brazil, but we have some cases that we are also worried. He also mentioned many nations have also useful national human rights institution, also called ombudsperson, that can assist climate activists and human rights defenders. Amazing, here in Brazil, we also have some public institutions that are that have in its duties to protect human rights and climate activists and environmental and indigenous peoples. We also need all nations in the global north to pass laws requiring environmental and human rights due diligence, covering the entire value chain of business based in their nations, but operating in the global south. That's one thing that is super important in terms of thinking about these transnational cases. I don't know if you ever heard about a big case in Brazil that was the Mariana disaster of a dam here in Brazil that killed lots of people. We had another dam disaster years later in a city called Brumadinho. And today we have a case brought to the British court, and they won finally. After 10 years, they won like this decision in the UK, and people in Brazil are celebrating this decision because it's a case against some big mineral companies. If you want to look for it, it's the Mariana Dam case disaster. But again, let's try to move on. I think we have some ideas which combines the political context in terms of thinking the institutions, are they functioning, are they not functioning, and of course it's important to take a critical look of what means to be functional or not functional in terms of what the legal lens that we are, and the sociological lens that we are using to see what is functioning, what is not functioning. But of course, we have countries with some human rights problems in terms of free liberties and having democracy or not. And of course, this brings more complexity to when we're thinking about a climate case, a climate litigation case that could protect more the climate defenders and the human rights defenders. This is one of the ways to think about this. The second thing is to try more in these procedural responses. And we've heard with our colleagues here that we have, for example, when we are thinking about procedural or maybe trying to bring an injunction to prevent a very slow case to go on the courts, which is very common in places like Brazil and other global south countries. Or three, we can try to build strategies using transnational and global coalitions to try not to put all the attention to the people that are in the front lines, and we're trying to use other institutions as legal and institutional shields for that people. In Brazil, we do that a lot. For example, when we have, for example, an indigenous leader that lives in the territory and he's facing some type of risk or violence, we can bring another organization to try to protect that territory, but not in the direct name of that people that is in danger. So we can try to build this strategy of being a legal and institutional shield against other types of violence and risks when we're thinking again in these more vulnerable groups. But again, Professor Ayodele, I would love to hear you again, please.
Okay, yeah, thank you. Yes, I have also been reading the suggestions in the chat from David Boyd, and I can see they say there's a book which is interesting. But what I wanted to say is, well, I don't say historically, but in the past, but not too distant past. I remember when I was working on my PhD thesis, and I was looking for how to bring justice to the oil-producing region of Nigeria and the rights of the people there. Because if anybody looks into the case of the Niger Delta, you find out that it's one of the most polluted places in the world. It was an environment that was pristine and good, and the people there live in deplorable situations. And one of the things I had advocated, which was almost 20 years ago, down to about 16 years ago, was that because people were not getting justice within the country, especially when it came to the big issues as to the environmental restoration, the pollution to start with, the oil spills, and you juxtapose that about with the attitude that is going on in the global north, wherein I always tell people that when it was the Deepwater Horizon disaster, I remember I had some BP shares I had bought, hoping to make some money to augment my school fees, tuition fees back then. And it took a big hit because, of course, with that disaster, you could see there were claims, and the government, the US government, held the company to account, and the subcontractors and everything. And you can see the effort that was put in to restore that environment and clean it up. The remediation was top notch. Although, of course, with those kind of disasters, nothing can be 100%, but they did try, and there were huge fines that were paid, running into billions of dollars. Now, with the Niger Delta, that's not the case. You go there, anybody goes there, you're disgusted by what you see. And so one of the things I had advocated back then was that communities need to go and sue these multinationals in their own jurisdiction because they have better laws and better enforcement, which has been going on, well, not on the level as I would have liked, but I mean, you could see some big judgment comes. You have all these Upabi and four fishermen cases, and you see them, they'll go to places like the Netherlands, they go to the UK and try to prove their cases. An uphill task. I'm not saying it's easy, but we found that by then that the multinationals do not have the protection of the government like they do in Nigeria. And this has meant that, of course, they've had to like compromise on some level and pay out some big bucks that the communities will receive. But like the other Nigerian Chukwuka had said, there's a lot of complicity on the part of the people who are supposed to protect these communities, state governors, local government chairmen, the community heads who compromise and take a payout personally to live large while their people continue to be impoverished by the activities of the oil companies. And again, you know, Nigeria is a resource-rich country. Right now, with energy transition, what is happening is we are trying to pivot away from fossil fuels, which is not being done fast enough. In Nigeria, gas flaring has been outlawed since like 1984, over 40 years ago. But there was an out that was given, a bit of a loophole given that they can continue to flare gas and pay a penalty, and that has happened. And with the new Petroleum Industry Act of 2021, there's still that. So gas flaring continues till this day. Now, the thing is, if we're going to make sure that we transition, you're thinking, oh, resource-rich Nigeria, we have minerals, one of which is lithium. And so you find out there was a lady from Netherlands that was talking about communities owning and having a stake in their resources. Unfortunately, in Nigeria, the constitution vests all minerals and natural resources like that in the federal government. Even if you own your land and you've held it for hundreds or thousands of years, anything that relates to any natural resource or mineral belongs to the federal government. And so you have to sit back and take the 13% derivation, which normally does not come to your community directly. It's paid to the state. So whether your community does not even have any resources, the state gets it. And it's not like it's not poured into these communities. And so this is a problem that we keep seeing. And yes, I agree with David Boyd's suggestion that global North countries should have laws that insist on, of course, environmental protection and things like that. And if you're going to do business and you're a company from the global North, then you would hit that. That kind of worked with like for example, the UK bribery law, bribery act. And you see that here in Nigeria, of course, on the corruption index, we don't rank very well. We're near the bottom. And so corruption is very high. So people pay to get out of sticky situations. And so when you're thinking of things along those routes, you need pressure from the external angle. So if, for example, our African Union was as strong as the European Union, for example, they would have had an overarching supernatural body that can hold the Nigerian government to account. Unfortunately, we just have, I hope I'm not rambling on too much, but we just have to deal with the situation where we have to take whatever it is the government dishes out. I'm not saying the government is all bad, but the interest of the people and the human rights of the people is not at the forefront of the government's mind. What they seek to do is they want more money, they want to get more money, get their hands on more money. And even in things like now we're talking of climate change, climate financing, the question is, when we get this finance, is it going to go to mitigate the effects of climate change, you know, have adaptation and things? Our climate resilience is really low. So the next stage we are going through now, even with the energy transition, not just because it's not just here in Nigeria, whether with all this now, with the mining and the lithium and all, we can see there are people in the northern part of the country that are beginning to suffer what the people in the Niger Delta suffered. And people are being displaced and there's insecurity and you have theft people are going there, there's mining, it doesn't really come to the national purse. And it's an agenda that has been alleged to involve some powerful individuals and cabals and things like that. So at this point, it's important that the countries in the global north with clout need to come down hard to make sure. It may seem like you're interfering with the sovereignty of another country, but we need to do something to ensure that the environment is protected, not just for us, but for generations yet unborn. Thank you. I'm done, if you can hear me.
No, okay. I was looking for the unmute button. I'm gonna try to pass more content now. I think we had a great discussion here. Thank you guys for participating. The idea of the workshop is to put us in conversation and to bring different perspectives and ideas, more food for thought. So now I'm gonna try to speak of typologies of climate defender litigation, just to put back my slides. Just a second. I'm gonna put my slides back. Let's see. Can you see now?
Yeah, confirming we can see that.
Okay, thank you, Tejas. In our conversation, we started to talk about all these types of climate defender litigation, combining climate litigation with the defense of human rights defenders. So we could see some protection cases that are challenging criminalization and of protest, of occupation. We have this type of cases more in countries that have some issues regarding free liberties, for example, contesting abuse civil claims by corporations. That was what Professor was mentioned just a quick time ago. Seeking injunctions and protection measures for defenders at risk. We mentioned this when I talked about the case in Brazil. I think we heard something about this from New Zealand also. Participation and access cases. We didn't talk about this one, but this is a very important, because we started to talk about this casual agreement, but we didn't talk about how can we put the litigation to have access to information, free and prior and informed consent. In terms of the right to information, this is crucial, because we know in different parts of the world, people have more or less access to public information. Here in Brazil, we have different types of law that grant access to public information here in Brazil, and we can, for example, just enter in a governmental website and request the information, and they have like 30 days to 60 days to provide the information for us. But I know that is not the reality in all of the countries. So in some countries, you have to file a petition, put a case together just to get access to information, and then with the information, we're gonna be able to put a climate case in the court. So when we're talking about trying to build the strategy of a climate defender litigation or a climate litigation itself, the idea is to combine all these types of strategies. But also, we didn't talk about one of the main problems that we have in terms of looking for the communities and the social movements, and not only here in Brazil, but in other countries that have indigenous peoples and local and traditional communities. There is the free and prior and informed consent, the right for a free, prior and informed consent. You know that we have legislation about this. We have like labor legislation about this that protects indigenous people to have their right to consent when, for example, a company wants to start a new project in some place. If there are local communities, traditional communities, indigenous communities, the idea and the right that they have is to be consulted. But in so many countries, this right is not followed, this right is denied, and most of the problems that we have in terms of local communities and some types of enterprises and some types of industries, they arise basically because when the project started, the owners of the project, the people that were involved in the project, they didn't consulted the indigenous people that used to live in that area or have their land rights on that area. So another type of climate defender litigation that is super common is in the intersection of land rights, prior consent, and some types of enterprises that have some type of environmental question. So I have some. Now Professor Mary Claire, she knows that I just had my PhD defense committee and she's doing this again with me right now. So this typology is fascinating, she's saying. Where should SLAP, okay, we just passed SLAP lawsuits feed. As leaders of a youth organization in Canada, we were subjected to a SLAP suit when we were protesting the clear cutting of the ancient temperate forest at the age of farm. Such processes are used to silence activists who often do not have legal defense. So we were talking about these labs here, not in terms of the typologies of climate defender of litigation, because when I think about a climate defender litigation, it's pro climate defender, it's pro the defenders. Now, and I see SLAP as a type of risk, also of not defender climate litigation. So I put them in the label of these SLAPs. But of course, they are related because when we are thinking about the strategies of putting together a climate defender litigation, we have to assume that the risk of having a SLAP is very, very important to consider. But moving on in terms of the substantive rights cases, so first we have the protection cases that are more focused on, I don't know, maybe the safety of the people that are involved in this type of cases. Number two, the way that these groups can participate in the environmental and the climate governance and how they can access their rights. And here in Brazil, we are doing a great job in terms of thinking not only in climate litigation, but also now of access to climate justice, trying to shifting the narrative, not only thinking about the climate litigation as a way to defend rights, but the opposite in terms of how can we build more institution and strengthen to those institutions be able to grant access to climate justice. And these dialogues with someone that was talking about giving agency to the social movements, to the vulnerable groups. So it's important because those two types of looking to the climate litigation are related, but the strategies to build them are, they're different. As I see here in Brazil, in my experience, when we have more climate litigation case, there, in some ways, there are more top-down cases, not because I think they are, when we think about top-down things, people assume they're not good, but I'm not saying that. I'm just saying that part of the big cases in Brazil, they were like top-down because they were brought by like big environmental organizations here in Brazil or from big political parties, because here in Brazil, political parties can sue the government. They were more like top down, so they had this strategy of trying to build structural cases, and then with the response of the courts, they could strengthen their rights. But now I'm thinking more, how can we shift these strategies in more bottom-up attitude, in terms of, okay, here in Brazil, we had some great victories in terms of climate litigation cases. Now in Brazil, I think I put this in some slide, here it is. So to us to talk a little about the Brazilian experience, that dialogue with the idea of how can we defend the climate defenders. So here in Brazil, with these more top-down cases, because they were brought between the Supreme Court in Brazil, we got some great precedents in terms of new ways of thinking climate, the environmental rights in Brazil, that they are not just environmental rights, now they're environmental and climate rights, because now in Brazil, we are looking them as part of a combined interpretation. For example, we had this case, which is kind of famous one, the climate fund case here in Brazil, that was paralyzed in our last federal government. And then at the time, some groups started a litigation against the government in order to restore and to put the climate fund to work again, because it was like paralyzed. And then not only we won the case here in Brazil, but in the decision, the Supreme Court in Brazil affirmed, and we, as some researchers have said, it was the first time that a country, the judiciary of a country, said that the Paris Agreement is not only a climate, is not on part of the climate international climate regime, but also part of the human rights, the international human rights regime. So now in Brazil, when we are talking about the Paris Agreement and the international rights, the international rights that are related to the Paris Agreement, we are talking in Brazil about human rights. And that's super important for us, because here in Brazil, human rights have a different type of legal protection. They have like a plus protection here in Brazil. I couldn't explain that better than this. It's a different type of legal protection, and that's good for both of the movements. It's good for the human rights movement, and good for the environmental and the climate movement. But not only we have this case that is super interesting, but we have another case of another fund that is also a climate fund, where it's more focused on the Amazon region. Is this name is in Portuguese, ADPF and ADO. It's the way that we call our constitutional legal actions here in Brazil, and you don't need to understand them. It's very peculiar of our legal regime. But in those two cases, our Supreme Court, STF, which is the Supreme Federal Court here in Brazil, they, for the first time in our history, we could put together environmental law, climate law, human rights law, and constitutional law. And now there is this interpretation that when we are talking about climate, the climate negotiations, for example, or the climate regime, that in some countries people are still thinking that they are like voluntary contributions. The climate law is more is more in the political side of the world, and not in this legal. Here in Brazil now we have this interpretation that climate law is a duty, the government has the legal duty to protect not only the environment, but also the climate system. So you have this type of legal obligation. And this is really related with the advisory opinions that we were talking about. Not only the Inter-American one, but the International Court of Justice also. We are seeing right now this shifting approach from this voluntary idea of the climate law to a more obligational way of look to the climate law. And I think that's super interesting because we are not more in the time of that's Gabriel, the activist, say, not only the Gabriel legal scholar or legal lecturer say, we're not more in the time of negotiations, we're in the time of implementation. We have to put things to work. So I do believe that this shifting approach into climate law, it's a great deal for us trying to save the world, our children, and so on. But as I can see, we don't have much time left. I just want to check. Oh, here is David Boyd. He was saying, no, I'm seeing, he was saying what I was mentioning here in Brazil, because yeah, I'm just gonna read what David just said, because he's bringing us the perspective on this more international side of looking to the climate law that we are seeing right now. And we are seeing this also in Brazil from the Brazilian way of the precedents that we have here nationally in Brazil. But what was I was mentioning the end of my thinking is that this is very related to what is happening with the new advisory opinions that we have today. So I just want to read what David said. Just a reminder to everyone that a safe and a healthy climate is one of the substantive elements of the right to a clean, healthy, and sustainable environment. Perfect. Here in Brazil, we have the same way of reading this right, because here in Brazil, we have in our constitution the right for health environment. There is in our constitution the Article 225, the Article 225, and for many years we only understood that as part of the environment. But now here in Brazil we have this combined interpretation that when we are talking here in Brazil of the environmental protection, we are also talking about the protection of the climate system, as it says in the UNFCCC and with all the information that we have from the IPCC and so on. So this is really combined. And as David was saying, confirmed by Inter-American Court of Human Rights, US courts, and others, and I would add Brazilian courts, and the right to a healthy environment is recognized by the International Court of Justice as well as law by, that's great, 165 nations. I know that the UN reports, they have this data of how many countries have the right to a healthy environment. That's so great to have this information. States have obligations to safeguard the climate system by taking mitigation action and regulating emissions from business, implement adaptation measures, and collectively take effective and equitable action to achieve the 1.5-degree target in the Paris Agreement. Key point: these are obligations for a state, not options. Perfect. That's the way we are moving our, I don't know, I think it's we are living like a super and exciting moment for climate law, for the environmental law, for the protection of human rights. And we have to share these ideas more and more. Here in COP30, we are having lots of events in the past 5 days, talking with judges, with lawyers, with policymakers, talking about the advisory opinions, the work that the special rapporteurs have been doing the past years, talking about all these climate litigation cases that we have so many good decisions, not only in Brazil, but in other countries. Now we have some colleagues from other jurisdictions that are giving us some good examples and good practice in terms of the subjects. But as I mentioned before, I think we are running out of time. And unfortunately, I have another panel to attend here in the Amazon, but I can send you my presentation. I would also love to talk about this indigenous case from the Torres Strait Islanders, which brought a case between the UN Human Rights Committee. And I studied this case for my PhD, and it's an incredible case. They won. It was one of the first times that we have a declaration from the UN human rights system that there is this connection between human rights and the climate change. That is something that we can look into, and is a case brought by indigenous people, a really great case made in partnership between the indigenous peoples of the Torres Strait Island, which is in the Australian country, with this articulation of a global north organization that is Client Earth. And that's was I was mentioning before, the importance of putting together these transnational, not only the transnational cases, but this is not a transnational case, it's an international case, but in terms of the transnational alliances that we can put together to have these cases, and I don't know, maybe to see strategies that can strengthen them to be more successful in terms of the results. Let me see what we have more here to. Yeah, I would say something more about loss and damage and just transition, because now the things are getting more connected. Here in Brazil, we have lots of cases that are dealing with climate damages, and how can we quantify climate damage? How can we expect to make the polluters pay, as the slide says? And yeah, here how to quantify damage, climate damage. Here again in Brazil, we have some great experiences in terms of how can we think about the social cost of carbon. Here in Brazil, we made some methodologies that are now being used by the judiciary here in Brazil, that have some calculators, some ways to calculate the climate damage using the social cost of the carbon. Here we are talking about safety and the procedural rights that we mentioned before when we were thinking about the strategies. Here again, talking about the alliances, the local organizations, coordinating with national litigation, and connecting them with media. I think we mentioned before also the strategy of putting together some campaigns to have more public opinion support. And then unfortunately we couldn't talk more about this, but I was super happy that you engaged with my workshop, because I know how difficult it is to put together a workshop online. People always get very shy, but it was really amazing. And here I'm just putting together some takeaways and next steps. So of course, that climate litigation is now a central arena of climate politics, with more than 3,000 cases globally and rising. And I'm starting to say that Brazil and other global south countries are not only laboratories of climate litigation. we have been reading lots of content that says that Brazil, Colombia, Pakistan, they are like climate litigation laboratories. I would say that we are now producers of doctrine and precedents, and we are like also leading some of the strategies in terms of combining climate, human rights, and indigenous rights, and that the litigation can protect. We talk about this. Litigation can protect or endanger climate defenders, so we have to be really careful when we are thinking about these strategies, not only to avoid slaps, but to avoid violence against the people that we are trying to protect. And unfortunately, we couldn't talk about more about compensation and reparation cases, but I do recommend you to take a look in this Australian indigenous case from the Torres Strait Islander. There is it's a great case. It has lots of material about it. So yeah. Maria, that's a good question. Laboratories in what sense? Because if you read some of the climate litigation literature, normally countries in the global south, they are put in this position of being a laboratory in terms that we are experimenting things. Like we are trying to put together things that are new. But when you have like cases in the global north, they are like the leading cases. And here in the global south, we are like the experimenting cases. And now I'm trying to change the narrative because we have like countries like Brazil, Colombia, that are not just only laboratories in terms of we are experimenting things. No, we are giving new precedents, we are giving new strategies, we are putting together a new doctrine, and we are part of this global conversation of climate litigation, not some laboratory that we are experimenting. No, we are delivering results. We are putting together some big and great actions, and when we have to, instead of doing this, we should establish a global conversation about climate litigation. And that said, I just want to thank for the opportunity. I'm gonna put here my email if you need anything. I'll be here in Belém until the 24th, being parts of lots of events, going to the blue zone, to the green zone, and I'm, of course, at your disposal to continue the conversation. And again, I don't know if Professor Marie-Claire is still here, but thank you, Professor, for the opportunity. LACLIMA is really happy to be part of this course. And I hope you guys had a great time. And I don't know if I had to pass to Tejas to finalize our session here. And I just want to say thank you again and bye-bye. See you next.